Let me follow up about this matter.
Yes.
So, you have 5 witnesses that come before you.
Yes.
The complainant child, who gives evidence. The police officer, who the child went to report to, gives evidence. The grandmother of the child, who confirms that she went to the police station and found the child there. The medical officer, the investigative officer. And when you hear all these witnesses, you then conclude that the accused person has a case to answer. You then proceed to the defense, and you say that the defense says he's been framed by the complainant's mother, and also that the accused person produces a letter from the director, from the DPP, from the Director of Public Prosecutions, to the effect that the standard required for prosecution of sexual offenses has not been met. So it is the accused person who produces a letter from the DPP. The DPP does not come and bring this letter, and there is no witness that comes to confirm the veracity of this letter. But you do take that letter into consideration, and you do take the defense of the accused who says he has been framed by the mother of the complainant. But you do not say at all, in fact you do not refer ever again to the evidence of the complainant child at all. It doesn't come up again. And you then focus, as Commissioner Omanza said, on the issue of penetration. Finally, when you get to the end of your judgment, it is unclear. You said you've acquitted him of what? Which offense? You didn't say. You've just said it would be unsafe to convict him and proceed to acquit him under Section 215. Acquit him of what specific offense? So it is not clear at all. So I want to come back to you and say, now you can answer, if you put him on his defense, it is not clear, therefore, how, having satisfied yourself that the evidence was sufficient to put him on his defense, how then, and for whatever reason, because it's also not clear, you decided to acquit him. And also, just, when I look at this judgment, Your Honor, and I look at your other judgments that you have, there is such a difference. Your other judgments are clear, your analysis is clear, you quote the law, you quote case law, you have your final orders in which you conclude, but in this one, this particular judgment has none of those. So are you in a hurry? What has created, why does this judgment look the way it does compared to your other judgments? But I would like, if you can answer those questions. Why did you disregard the evidence of the 5 witnesses whom you were satisfied had made a case for the accused person to answer? Why did you consider a letter from the DPP given to you by the accused, not by the DPP? How did you ascertain? How did you ascertain that there was a grudge, or there was a, I think, well, that's not the word you use, that the accused person said he had been framed by the complainant's mother? How did you ascertain that? He had no witnesses? How did you come to that conclusion? If a member of the public was to read this judgment, they do not know how you have come to that conclusion and on what offense this accused person has been convicted, because you did not say. So if you can answer those questions, please.
Thank you. Thank you, my lady. My finding was in respect of both the principal and the alternative charge, and I would also want to state clearly that I considered the evidence in totality. There was the evidence of the investigating officer who stated that she went to the scene immediately. That is evidence that was tendered on record. Then there was also the evidence of the clinical officer, who indicated that he examined the victim and reached a finding. So I considered all that evidence, and then also the accused person who gave an indication that initially there was a letter from the ODPP that there wasn't sufficient evidence to charge him, but later on he ended up being arraigned in court. So really, honorable commissioners, I was just looking at the whole matter in totality, and I put the accused person on his defense, because that was not a matter that could not just be dealt with at that point of no case to answer. I wanted to have an opportunity for all the evidence to be tendered before me, before I could be able to reach a finding.
Okay, that's all for me.
Thank you. Okay. Yes. No, just to finish my session. Thank you, Chair. Good afternoon. Good evening, Your Honor.
Good evening,
you need water?
Yes.
Okay, please.
Thank you. Thank you.
Okay. Yeah, I went through your sample writings, and I do agree with Justice Njoki that what you presented as your samples and what we have with regards to the complaint we receive, they are totally different. You can't even tell they are from the same author, because these other sample writings you presented, they are coherent, good analysis, linking facts to applicable principles, but on this particular one, there is a huge gap. Still, to that matter, you go and identify issues for that determination. This is a 12-year-old girl, and among the one issue you want to establish whether the prosecution has proven its case is that, one, the accused person had sex with the complainant. This is a 12-year-old child, but you're saying that is an issue for determination in an incest case. The accused had sex with the complainant. Number two, whether it was willful and unlawful, again in an incest matter. And number three, the accused person is the complainant father. So the first two, are they necessary in such a case? Is it an issue that you needed to determine, an issue for determination?
Thank you. Thank you, Commissioner. I think I was setting out the general parameters. Before now I could come to, I think I looked at it in terms of the general parameters in respect of that kind of offense.
But
before now I could narrow down.
So the consent bit, was it necessary? Was it an issue that you ought to have determined?
No, the issue of consent doesn't arise.
So that particular issue of determination should not have been there.
That issue is not relevant. That is why I'm saying, Honorable Commissioner, that I may have set out a broad, general kind of scenario.
Even if it's broad, Your Honor,
yes.
You agree with me, a 12-year-old, the issue of consent would not arise at all. It should not even be an issue of determination.
It doesn't arise, and it's not.
And then you also make reference to a finding from a doctor who says that there were no bruises, there were no tears, the genitalia and hymen had been broken earlier. So what is your understanding when you say the hymen had been broken earlier? There was no discharge or blood from her private parts. He did not detect any spermatozoa, so he could not, therefore the issue of penetration could not arise. Is that how we are supposed to handle sexual offences matter? Those are some of the things we need to consider.
Honorable Commissioner, the issue that arose when the clinical officer testified was that he reached a conclusion, really, that the victim's genitalia had not been touched, if I may put it that way. That was principally, that is how I was looking at the whole picture,
okay,
to determine in terms of that.
Okay.
So that was the victim's genitalia touched in any way? That is an issue that I had to find out and be sure.
Okay, but the complainant had mentioned that she was defiled.
Yes,
Yes.
The evidence given by the complainant,
yes,
sorry, the victim, so to speak, was that the father defiled her.
Okay, thank
That
you.
was her evidence.
Okay, thank you. All the best. Thank you,
Thank
Chair.
you.